a matter of PMC, a child finds another litigation related about FLR and a local health board.
Good morning, Mr. Ware.
Well, please, my Lord, Master of the Rolls, my Lady and my Lord. I appear on behalf of the appellant, my learned friend Mr. Oldham, who sits behind me and to my left, and learned friend Mr. Hyam of King's Counsel appears on behalf of the respondent. We then have a number of interveners. So we have Mr. Brown, who joined us late, but is here on the front row for MP2, as that intervener is known for these purposes.
Is the BBC?
Well, it's been anonymised to MP2, my Lord. So
well, that's ridiculous to anonymise the BBC. Absolutely ridiculous. Thank you.
Lord.
The BBC, Mr. Brown, is your client.
Mr.
Yes.
Mr. Brown for the BBC, my Lord. Miss Patterson and Miss Scott for the official solicitor.
You're going to anonymise her too?
No, my Lord. There was a reason. It was perhaps at this since that particular cat is out of the bag, it perhaps matters not, my Lord, but it related to the fact that it was the BBC. Well, I didn't need to go into.
Okay, on you go. Sorry.
My Lord, yes. Miss Proops and Miss Reddy and Mr. Cottrell for PIBA, and Miss Greeny, King's Counsel. Sorry, Miss Proops of King's Counsel, as advocate to the court.
Yes.
This appeal is concerned, as this court knows, with the appropriateness of making an anonymity order, by which I mean a withholding order and a reporting restriction order, which I will at various times no doubt end up shortening, if that's okay, to WO and RRO, in clinical negligence litigation involving a claimant who is A, protected party, B, set to recover very substantial award of damages, almost certainly by compromise, in his ongoing civil claim, C, highly vulnerable and, we would say, obvious risk of exploitation, D, in which some information about the claimant is already in the public domain, and E, in circumstances where the press have indicated an intention to produce a further story about the claimant, which triggered the application for anonymity back in November last year. And as this court appreciates only too well, hence making of various orders by my Lord the Master of the Rolls, the issues raised are of considerable significance, given, amongst other things, the importance the court attaches to the principle of open justice, and should be seen against the wider backdrop of the approach of the courts to anonymity orders across the board, as enlarged upon by the advocates of the court and the official solicitor. The issues arising in this appeal can be seen in three parts. The first two are those set out in the grounds of appeal. That's in the core bundle at page 26, my Lord. That's that should be a reference to the amended grounds of appeal, in which you see the first issue goes to the court's jurisdiction to make an anonymity order, in particular a reporting restriction order. It's not an issue between either the parties or the interveners that there is jurisdiction to make a withholding order, but it's one of the questions that the court asked yesterday to go into that issue, which I'll come to in a moment. The second issue is whether the learned judge below, Mr. Justice Nicklin, was respectfully wrong not to make an anonymity order in this case. And the third part of the appeal I would describe as the linked issues, which the court's likely to need to address, at least to some extent, when seeking to address the first two issues, more specifically the status of X and Dartford and the proper approach to anonymity applications made after settlement of a personal injury action in advance of the court approving the settlement reached between the parties, and linked to that the proposal from the official solicitor that this court should replicate procedures applied elsewhere, for instance in the Court of Protection, or by way of default position make an anonymity order from the outset of proceedings. Now I propose very much to focus on the first two issues and very little on the last issue. I can make the position of the claimant clear at the outset. So far as concerns X and Dartford, there hasn't actually been a full frontal challenge to the accuracy of the decision, which which in any event is a decision of the Court of Appeal and it's the ratio of the case.
It is a point that I'd like you to go back to at some point in your submissions. But I think we need to look quite closely at what Dartford did actually decide, because
Yes,
my
ma'am.
understanding of the case is that it was really about what we would now refer to as withholding orders. I mean, in common parlance, you talk about anonymity orders, but that the idea of it was to prevent the discovery of the identity of the individual. And there's, as I read the judgment, there's really nothing in it about what we've now referred to as reporting RROs.
Oh, it was definitely about reporting restriction orders, my lady.
Then
An order was made by the Court of Appeal afterwards, which I've kept. I've got it in my computer somewhere. And it was in the form that became the PF10.
But if you, that may be, I don't doubt that, but if just looking at the reasoning, I suppose,
I
it felt
understand
very
that
much that was the what they were tilting at was the idea of anonymity, so protecting the identity of the individual. But it would be useful to look at that.
Lady, yes. I don't think it's in doubt that the distinction being drawn between a WO and an RO is one, important, and two, helpful, and three, was not drawn certainly by us as advocates to the court, and not so obviously drawn by the court in its judgment. That is correct. But the intention of the Court of Appeal is as shown by the order that they made, and that has included an RO.
Well, we're concerned with the reasoning of the Court of Appeal and
Yes,
what
Lord.
it binds us to decide, and for that purpose we'll need to look at that decision quite carefully.
Yes,
There
Lord.
is a clear distinction, Mr. Ware, between a withholding order and a reporting restriction order in the authorities, and we need to treat them differently. The judge doesn't seem to have been wrong, and I'm not sure anybody is saying he was wrong, to have treated them differently and separately.
Well, differently, so far as concerns jurisdiction, is not our case at all, but I understand that they need to be taken in turn, and the court needs to analyse whether there's in fact the same jurisdictional basis for making a WO and an RO. So we say they're not treated differently.
Well, on authority, there's probably not the same jurisdictional basis. There would be a different jurisdictional basis, according to Cuja, to conceal what has happened in open court.
My Lord, well, can I come to Cuja? Probably best rather than being taken out of turn. Certainly that's not our case, my Lord, at all.
I think we know that's. I think we've got that.
We know it's not your case, but you're going to have to explain
Absolutely, my Lord.
why your case
I'm
is
keen
right
to.
and
I'm
Cuja
keen to,
is
my Lord.
wrong.
Very keen to. Can I, before I get straight to that, can I just make some general submissions in response to some of the submissions which have been made by the respondents and the interested parties, and in an effort to highlight what we say is, and I don't mean this in any way rudely, but the limited relevance to the appeal of the guidance given by the court in Abassi. Just because Abassi has come out very recently doesn't mean Abassi holds all the answers to this appeal, and I wish to try to explain our direction of travel in relation to the appeal in the light of Abassi, if I may. Can I make 5 opening submissions? The first is that the claimant recognises that we're engaged in ordinary civil litigation at this stage, and that's because the case is not yet settled and we're not yet seeking the court's approval of any such settlement. And so it's right to say that the court is not carrying out an essentially protective function, as it is when it decides whether to approve a settlement. And for that, I say, see X and Dartford at paragraph 29, which is at page 639.
Sorry, why are we looking at Dartford for the proposition that, as a matter of fact, the court is not approving a settlement in this case?
Because I'm seeking to clear the decks, my lord, so that the court is in no doubt as to what it is that we are recognising we're facing at this stage. We are not engaged at this stage in the protective function of the court, as is applied in X and Dartford. The following submission we therefore make is we're not engaged in exercising the parens patriae jurisdiction as the Supreme Court was in Abassi. And for reference to Abassi exercising the parens patriae jurisdiction, see Abassi at paragraph 57, page 1244.
Well, I mean, that's a sort of putting the cart before the horse, isn't it, Mr. Ware? We're looking at all possible sources of jurisdiction, A, for a withholding order, and B, for a reporting restriction order in the circumstances of the case. So to say this is nothing to do with the parens patriae jurisdiction of the court may be right, it may be wrong, but it requires argument. I don't.
My lord, forgive me,
This
but
is a. Just to be clear.
yes, my lord.
This is a very complex, difficult, and important case.
Yes, my lord.
So there are no assumptions to be made as to what's relevant and what's not relevant and what's the case and what's not the case. We need to look at it from all angles, which is why we have many interveners, meaning no disrespect to any of them. We're delighted to have your help. And we're not making any assumptions.
No,
so
my lord.
I don't understand how you can say that the parens patriae jurisdiction of the court is not relevant here at all.
I haven't said
it.
it. I haven't said it's not relevant at all, my lord. I'm saying that the court is not exercising its parens patriae jurisdiction in ordinary civil litigation in advance of its determination whether to approve a settlement in personal injury litigation.
Right.
We
You
consider
say
that
can't?
to be reasonably uncontroversial and hopefully helpful to the court to set.
You say it can't. I mean, let's say it thought this vulnerable child needed to be protected. Could it not call upon the parens patriae jurisdiction? And if not, then why not?
My lord, can I seek to answer that by going ahead to the jurisdiction that we say so plainly applies, which then leads the court to understand that there is no need for the court to say, but shall I generate parens patriae jurisdiction in ordinary civil litigation? And in part of the it's not irrelevant, the next part of the submission I was going to make was that the fact that the court is likely to end up being asked to approve a settlement of the action is relevant. CPQ against Royal Free NHS Foundation Trust, Mr. Justice Martin Spencer at paragraph 9, the reference for which is page 851. So that's me trying to say to the court, this is my case. I'm not seeking to apply directly the parens patriae protective jurisdiction. I am, however, cognizant that the case is likely to settle, that when it settles, the court will be engaged with that jurisdiction, and that is a relevant matter for the court before it engages that jurisdiction.
Which page is Mr. Justice Spencer?
It's page 851, my lord.
Thank you.
Second submission I was seeking to make was the claimant is seeking an anonymity order in the context of ongoing civil litigation, not a freestanding contra mundum injunction. So the position is not like that in Venables, where the claimant sought an injunction contra mundum and the court granted what I describe as a freestanding application, because it only because it found the claim engaged a tort of the breach of confidence. So those claimants just went to court only seeking the remedy of the injunction.
Well, we understand it's not like Venables, but what I don't understand is that you are not seeking a reporting restriction order. I thought you were seeking a forward-looking reporting restriction order.
Yes, my lord.
In the same way as is made in the standard form.
My lord, I am seeking a reporting restriction order attached to a withholding order in existing proceedings, and I'm about to seek to explain an absolutely critical, well, not to explain, submit to the court. In my respectful submission, there is a critical distinction which needs to be drawn and has been drawn by Lord Reid, which I'm about to come
Just
to.
before you go there, can I just really anchor this submission? It'd be very
Yes,
helpful
yes,
if you wouldn't
madam.
mind to me. I'm looking at, in fact, the draft order that was before the judge, and the orders are a combination of not publishing the name, the identity of the claimant. That's the withholding order bit.
No,
of
not
it.
public, not, well,
And then there's a second bit that talks about not disclosing any information which could lead to the identification of the claimant in these proceedings, which feels like it's more of an RRO type.
well, the not publishing is part of the RRO. Anonymising, the giving letters in replacement to the name is a withholding order. You're withholding
That's
the
the
name.
withholding bit. Yep.
The not being able to publish
Yep.
or publicise is part of the reporting restriction order,
Yep.
and the last part of what your lady read out is
Thank
a sort of add-on to that to make it effective.
Thank you.
all I'm seeking to do at this stage is, for instance, if I can then move to Abassi. So Abassi comes in parts because there is Abassi where the child is alive and there are proceedings afoot and the court is engaging its parens patriae equitable jurisdiction. After the child dies, there are no proceedings. And then you have essentially a doctor wishing to obtain a contra mundum injunction. And that is a Venables-like contra mundum injunction when somebody is just saying, I'm coming to court seeking the remedy of this injunction. It's all I want. And the Supreme Court explained that the normal route to obtaining such an injunction is by way of asserting a cause of action, for instance, in the tort of privacy. See paragraph 79 and following at page 1250. And at any stage, my Lord, of course, I'm very pleased to go to these paragraphs if it helps the court. Unless being invited to, I may at this stage seek to keep the show on the road, but I really don't mind if that's helpful. And the claimant seeking such an injunction has to support their case by evidence. That's set out at paragraph 81 in Abassi, ditto in Tickle and BBC per my Lord the Master Rolls at paragraph 69, 1193, which is another Venables style freestanding contra mundum injunction application, because these proceedings have taken place. They had judges involved. They're finished. Those were care proceedings, and now I'm coming to court. In fact, there may not be an application because it was the judge. It was a judge-made order. But now, out of thin air, in that sense, the court is deciding to make a reporting or not, to make a reporting restriction order. But
why is this case not exactly the same as that? Here we have litigation in progress, information in the public domain, and the claimant seeking to get an order that at the very least restricts publication and reporting of information in that case, some of which is already in the public domain. So why doesn't the strictures in Abassi that say if you want such an injunction you have to produce evidence and explain specifically why you need it, and why doesn't the strictures in Tickle at 69 apply directly, that if you were going to grant an injunction making the judges' names private when they had not been private before, you needed to apply for it and have evidence?
Because the position is completely different.
Right. What's different about it?
Because there are proceedings afoot. Can I take you, please, to A and BBC at paragraph 55? It's page 619, and I'm going to ask you to turn this up.
What we in authors?
A and BBC at paragraph 55. And for the avoidance of any doubt, our submission is that the critical case for this appeal, the critical case, is A and BBC, which I will repeatedly come back to.
Okay,
is the case that provides all the guidance that's necessary to get through the thicket in relation to this issue.
Could you help me with the tab number again, please?
My lady, yes, if you're using tabs, it's
415. 415. Got it. Thank you.
I don't know if you're then in two bundles.
So did you
I'm in
say...
a digital one bundle.
My lord, it's paragraph
54.
55, my lord, page 619. I'm going to develop this in a moment. So I'm going to start with this, my lord, but everything has to be done in stages. I will get there. I will seek to address all of the issues that my lord raises. But I have to get there in stages. Paragraph 55. It was submitted on behalf of the BBC the source of the court's power to allow a party to legal proceedings not to disclose identity in a situation where convention rights engaged is to be found in convention rights themselves rather than the common law. Ref. In re S and in re Guardian News. These dicta were not, however, concerned with the conduct of proceedings. They concerned a different issue, namely the jurisdiction of the English courts to make orders contra mundum restraining publicity relating to court proceedings. Now, Abassi is something different again. This is what I'm trying to make these submissions in opening, because Abassi isn't that interested in open justice, and I can give you the references to that if it's necessary, in the sense that Lord Reid and Lord Briggs seek to explain very carefully the limited engagement of open justice, no engagement of open justice in Hastrup case and limited engagement of open justice in the Abbasi case. And you can just go to court and say, I just want an injunction against the world. That's what I seek. Wolverhampton says you can do it. Abbasi provides a working example of how you can, depending on the facts, do it if you're a doctor who happens to have been involved in best interest decisions in relation to a child who's died.
So we got here because I put to you that this was not so very different from other cases where evidence had been required, so the contramundum, injunction, tickle, evidence would be required. And you said the answer is in paragraph 55 of AN versus BBC.
Yes.
But that paragraph, so far as I can see, but you tell me if I'm wrong, simply says that there is a big difference, which there is, between the conduct of court proceedings, which might lead to a withholding order, and an RRO where you are trying to order against the world publicity as to what has happened in court. That is a very different thing. We agree. How does it answer my question?
No, my lord. First of all, AN BBC, on the facts, involved a withholding order under the court's inherent jurisdiction, coupled with a RRO under Section 11 of the Contempt of Court Act. That's what happened below in a Scottish outer house court. But the thrust of the guidance from Lord Reid is all about whether or not the BBC can overturn the anonymity order of both parts, the withholding order and the RRO. So it is not accurate to describe this as a observation of the Supreme Court limited to distinguishing one case involves a withholding order and another one involves an RRO. That is simply not the position. AN BBC absolutely involves a reporting restriction order. The fact that it comes via Section 11 of the Contempt of Court Act for these purposes is not the point, because when one goes through the analysis of Lord Reid, he makes no distinction. Oh, now I'm in Section 11 of Contempt of Court Act. The whole approach I must take to this case changes. Not at all, which is why we say there is no distinction to be drawn as regards the court's inherent jurisdiction.
Well,
and the critical... Yes, my lord.
It would help me, rather than describing the case in general terms without going to it,
yes, my lord.
To see the case at some stage in its entirety. I don't
yes,
mean reading every word, but just
yes, my lord. I was proposing to go through AN BBC very shortly. I hadn't anticipated that these opening submissions would meet with such resistance, my lord.
They'll sometimes happen.
They're not being resisted, Mr. Ware. We just think this case is very important.
Of course it is, my lord, and I'm trying to set out the basis upon which we analyse these cases, and I was trying to clear the decks, perhaps not successfully,
right,
but at least if these submissions can be remembered for when I come back to them, my lord, that this heading was, the court is concerned with the conduct of proceedings in this case to be distinguished from an order contramundum restraining publicity relating to court proceedings. And Lord Reid references In Ries, and I'll go to it In Ries, because In Ries is a Cuja case. I won't go to it now because I'm going to get completely out of order. I'll start with AN BBC and I'll come back to In Ries. But the whole point of that paragraph 55 is to say those are different types of cases.
And that's your, can I just summarise how far we've got?
Yes, my lady.
That is or one of the bull points of your argument, is that if you're talking about reporting restriction orders in the context of ongoing litigation, that's different. You're looking at a different set of rules from if they're...
Yes, my lady. Of course, rules are unsurprisingly, there's lots of overlap. I mean, I'm not going to say there isn't. For instance, be supported by evidence. Am I going to say that we shouldn't have evidence in support? Of course not. But we're looking at the jurisdictional foundation now. We're not looking at matters of how to win your case in battle. We're talking about where the source is. And the source of your... it's very accurate. It's characteristically completely accurate language by Lord Reid. He distinguishes it from making orders contramundum, restraining publicity relating to court proceedings. So that is the freestanding, I want to now just restrain the publicity relating to proceedings. In other words, those are open court proceedings, and I just want to restrain it. I want my RRO as my remedy, I am going to court only to seek that remedy. That's one set of circumstances. The jurisdictional basis has been fully explained in the BASI. First up, seek your domestic cause of action, normally the tort of privacy.
So, I mean, I now get the argument. Thank you, Mr. Ware. What I don't really understand
Yes, Lord.
is what is the jurisprudential
Yes, Lord.
difference between an application to restrain, as he says here, publicity relating to court proceedings, and an application by an ongoing claimant
Yes, my lord.
to restrain publicity relating to court proceedings.
Yes, my
Why
lord.
is that different?
Because that's my next submission, my lord. That was my fourth
Okay,
opening submission.
good.
That the starting point when seeking an anonymity order as a party in ordinary civil litigation here involves the twin principles of the principle of open justice, which I would say / its qualifications. I'll come to that. Because it's actually the principle that lies behind the principle of open justice, which may sound woolly, but it is to do justice.
Okay, yeah.
And linked to that, securing the proper administration of justice. And those are principles which are fully applicable in the conduct of proceedings. The court is seized of ongoing proceedings. And again, to clear the decks, the principle of open justice may not be the starting point in the court of protection, but we accept it's a starting point here because we're involved in ordinary civil litigation. And it is for the claimant to persuade the court that it should, on the facts of the case, derogate from that principle to the extent of making the anonymity order sought. The principle that the court should so conduct their proceedings so as to secure the proper administration of justice is one that applies to any court in relation to its control over the conduct of its proceedings. Whether, for instance, that's in the King's Bench Division or the family courts or the Court of Protection or the Administration Court. Doesn't matter. But not necessarily the criminal courts. I'm just going to take you to two parts because I'll come back to this when we look at Cuja, if I may, so I might as well clear this out now. If you kindly go to page 418, which is 4.9, my lady, of the authorities bundle, you get In Re Trinity News. And this is...
So I didn't get the page.
Yes, my lord, sorry, it's page 418 of the authorities bundle, please. It's 4.9.
Trinity Mirror.
Yes, my lord.
Yes.
It's paragraph 22. And it says, Your Lordship have it. It says, Mr. Nickel begins his substantive arguments with two concessions. First, at common law, a criminal court has no power to forbid third parties from publishing evidence given publicly. See the Attorney General of Tobago case, which is the one that's relied upon by Lord Sumption and Cuja. When it arises, the power depends on legislation. Second, the Crown Court is a creature of statute and therefore lacks inherent jurisdiction. And that passage was approved, if you then go please to 4.10, the In Re BBC case, at page 453, paragraph 57.
Hang on, don't go too fast, please.
Yes, sir.
That passage was
That-
approved
if-
at where?
If you then kindly go to the next case, it's page 453, 4.10 of the authorities bundle. It's at the top, it's in the judgment of Lord Brown, it's paragraph 57. And your Ladyship and your Lordships will see, I'm reading 3 lines down from the top of the page. In Re Trinity Mirror was concerned with the Crown Court's powers to make anonymity orders, in particular under part of the Supreme Court Act. As pointed out at para 22 of the Court of Appeal's judgment, the Crown Court's powers are more restricted than those of the High Court, which arise under Section 6 of the 1998 Act, read in conjunction with Section 37 of of the 1981 Act. I'll come back to that later. The point is that the Crown Court is a creature of statute and does not have the inherent jurisdiction which this court is concerned with in this part of my submissions. So in all these civil proceedings, the court has an inherent jurisdiction, and I will obviously develop these submissions, but just by way of understanding.
Can I just understand that?
Yes.
The typical example of a withholding order is in black, in the Crown.
Yes,
What's
so I see from
what's the
RI and
Well,
or the socialist
it goes
worker.
back to the socialist worker case,
Yes, my lord.
and well beyond that. So that's a very long-standing practice of the Crown Court. These citations are about the lack of an inherent jurisdiction to grant an RRO.
Yeah.
It's a different point.
Yes, my lord, but that's
So that's the inherent jurisdiction you're saying.
absolutely.
Lack, not the inherent jurisdiction to withhold.
No, my lord.
Yeah.
Absolutely.
Just to be clear.
Absolutely. I know the court asks a specific question. Please tell me your case in relation to the source.
No, I'm just asking for clarity on
Yes,
what
ma'am.
your submission is at this stage.
Absolutely. So our submission is in all these civil proceedings, the court has an inherent jurisdiction to make, and rather than saying to make an RRO, it's to make such orders as are necessary for the purposes of the proceedings before it. I'll give you one of the passages in which this...
Can you just say that again, please?
Yes, my lord.
Civil court has such inherent
Has an
jurisdiction.
inherent jurisdiction to make such orders as are necessary for the purposes of the proceedings which are before it.
Well, that's very broad.
Oh, my lord, it's me borrowing directly from Lord Hope in Re BBC at page 439, 4.10, paragraph 13. And it's right to say that, well, I'll wait for the court, if I may, just to turn that up. So we're talking about page
410, paragraph 13.
Paragraph 13, page 439.
439.
439. This is the case in which the House of Lords was addressing whether or not it had power to make a reporting restriction order. And Lord Hope's language is careful, so he starts by saying, and it's right to take you to this, I think that this issue has to be approached on the assumption that it is at least arguable that the House had power to make the order, then references section 6.1 of the Human Rights Act, an important part to play when the court considering how it should exercise a power that's been conferred on it by statute, or in the case of the High Court, for example, is vested in it by an inherent jurisdiction. But it cannot confer on a court power that it doesn't otherwise have, that's section 6. It would seem, therefore, that the setting aside of an order that's been made without jurisdiction cannot be said to be incompatible with any convention right that its preservation might protect.
So where are you reading?
I'm at G, my lord, 439G.
Oh, right, sorry, I got the wrong paragraph. Yes, thank you.
And then Lord Hope continues that as the assumption must be that the court didn't have power to afford that its protection, but the House has an inherent jurisdiction to make such orders as are necessary for the purposes of the proceedings which are before it. And then he continues at H, I would be reluctant to hold the House did not have the power to make the order, even if, as it seems to be reasonably clear, it did not have power under the rules to do so. And what I submit is the same point was put in very pithy terms by Lord Reid in A and BBC at paragraph 76 on page 625. So that's 4.15. Para 76, page 625. At B, when Lord Reid says, put shortly, the order had to be made if the court was to do its job.
Sorry, Which paragraph?
Yes, my lord. It's paragraph 76. It's at B on page 625. That's Lord Reed dismissing the appeal, see paragraph 80, which is the appeal by the BBC against both the withholding order made under the inherent jurisdiction and the reporting restriction order made under Section 11 of the Contempt of Court Act. And I will very shortly go through A and BBC. So it's not so much a case of this court saying, well, there is inherent jurisdiction to make an RO. It's this court saying there's an inherent jurisdiction to secure the proper administration of justice when I've got a case in front of me. Thank you very much. And that's what I'm going to do. And if it's an RO, it's an RO. That's the right way in our respectful submission looking at it. And that's why it is not our case that there is a distinction to be drawn in that sense. Distinction on the facts of establishing your need for an RO, of course, but not in principle. Final opening submission of
So you say the judge was totally wrong when he drew what you say is an artificial distinction between a withholding order and a reporting restriction order in the context of ongoing proceedings.
in the context of the court's inherent jurisdiction. I've no difficulty with the drawing of a distinction, as I've sought repeatedly to say, my lord. Of course, there's a distinction. They have different types of order. The court has to always consider, is it necessary to make this order? So in that sense, a distinction is made. But jurisdictionally speaking, they both fall within the inherent power of the court, at common law, as I will seek to develop, which inherent power of the court gives it the power to secure that the job is done, the right job is done, that orders are protected, that they're not frustrated. And that's why we don't need to go to the parens patriae jurisdiction. We don't need, and it cannot be right, just standing back for a moment and thinking, can it be right that in a situation like this, the claimant's got a praenade, a tort of privacy? Absolutely not. You don't need to go there. That's the Venables type contraband and injunction relating to court proceedings. This is the court proceedings, conduct of court proceedings jurisdiction. So the final opening submission I was hoping to make was that the claimant is not seeking a default position per se for all protected parties applying for anonymity to prior to settlement of their claims. The distinguishing features of this case will be common to a subset of protected party claims involving profound injury, recovery of very substantial sums of money. And to that extent, if the claimant succeeds on this appeal, the approach this court will have adopted will no doubt influence or determine the outcome in comparable cases. But that is not, for the avoidance of doubt, the setting of a general rule. That is just the application of consistency by courts subsequent to this one within a judiciary when approaching cases that are materially the same. And I now turn, my lord and my lady, to the jurisdiction to make a withholding order. I'm going to address this in very short order, the jurisdictional basis, because the submissions I'm then going to make in relation to reporting restriction orders are the submissions
I thought your submission was that they're one and the same. I mean, I thought if I understand your submission correctly,
yes, my lord.
The court has power to control its own procedure and to administer justice fairly and appropriately.
Yes, my lord.
You can put it in whatever language you like.
Yes, my lord.
And as part of that jurisdiction, in controlling its own procedure, it has an inherent jurisdiction to make a withholding order as to the name of a party and also a reporting restrictions order as to what goes on in court. Now, I think it would be common ground that between the parties before us,
yes, my lord.
that if by that you mean to hear proceedings in private in an appropriate situation, that is correct. Where I think the people in this, on the other side of the court, if there really
yes,
are two sides, differ, certainly the judge differed, is that it is not just making an order that proceedings be held in private and are not disclosed out of the court room. to make an order that has the effect of stopping the press reporting on what has gone on in open court. That is a different kind of order with a different jurisdictional foundation required. So that's my problem. If you say the court has an inherent jurisdiction to make a withholding order and a reporting restrictions order,
Yes, my lord.
I don't quite see that, particularly in the light of Section 11.
Well, my lord, can I seek to get there again in stages? Your lordship accurately summarises A, our case, and B, the counter case that I need to meet.
Yeah.
And all I'm seeking to do at this stage is, at least we have clarity in relation to the position
To start with the withholding.
that we adopt. But because the court then says, well, tell us about withholding order, my first submission is exactly in line with the observations of my Lord Master Rolls. I'm going to do that, but I'm going to do that in relation to reporting restriction order, which will apply equally to withholding order in a moment. So in relation to a withholding order, all at this stage I wish to draw the court's attention to is, first of all, the learned judge below at paragraph 48. You don't have to go to it, but it's page 288 of the core bundle. Recognise that a withholding order is part of the general powers of the court to regulate its proceedings. We do not disagree with that at all. We simply say that's not the end of the matter.
Can we just, which page is it in?
My lord, it's 288 of the core bundle. You've probably got 4 PDFs, 4 supplemental. 288, my lord.
Paragraph 40.
Paragraph 48.
And the judge refers to Kuja, which I think you were just telling us that was not a different. It was different from your case, but actually Kuja is quite important in this case.
course,
Kuja,
it's
para
an-
1618.
It's an important case to look. No, I will never shy, lady, from any of the issues the court puts forward. I just wish to take them in a certain order that makes at least some sense to me, if I may. So I will come to an
But
address.
you're just saying, you're making a submission that you agree with 48, right?
I agree. Well, I haven't gone back to 48 for all of 48. I agree with the part that says that the
Only-
withholding order.
We need 2 sentences, so if you don't agree with it, we'd like to know why
Yes,
not.
my lord.
Having said you do.
It's the part where he says that with power to make a withholding order is part of the general powers of the court to regulate its proceedings.
Yes. And he says, as my lady points out, see Kuja at 16.
Yes, my lord, he says that, but that's not. I'll come to Kuja, but I'm just.
Okay, all right.
That's
all
all.
right.
I'm just
Don't-
saying.
don't-
I've been hoping to be accurate as to what it is that I'm saying. That's accurate, not the source,
You have to get.
not that
you
it's
have to get-
Kuja.
get
It's
up.
inherent jurisdiction, my lord.
Mr. Ware, keep calm. We are obviously keen to see Kuja, but we understand
Lord.
your submission now that you agree with Mr. Justice Nicklin that the power to make a withholding order is part of the general powers of the court to regulate its own proceedings.
Yes, yes, my lord,
Good.
and that which is set out in relation to withholding order is apt to apply also to a reporting restriction order. That's my submission. And so when you see this language, it's all the right language, because this is what it's about. It's another way of describing the business of securing the proper administration of justice, general powers of the court to regulate its proceedings. My
Do
lord,
you agree with the first sentence of the next paragraph, 49, that if a withholding order is made, it's usually to prevent the withheld name being discovered as a result of the proceedings? In other words, it's sort of aimed at stopping the cat getting out of the bag. That's the point of it.
I'm not going to make an open concession to that, my lady. I would say it's entirely fact sensitive. It's all part. It's my next submission is this: that both under the inherent jurisdiction of the court and under 39.24 of the Civil Procedure Rules, which reflect the court's general powers, and you can pick those up. Actually, I think it's at page 294 in the judgment. It's probably easiest just CPR 39.24.
It's
Authorities bundle
paragraph 68 of the judgment.
It's 68 of judgment, I'm grateful. Yes, it's at 2.13 of the authorities bundle. It's at page 108. That the court must order that the identity of any person shall not be disclosed if and only if it considers non-disclosure necessary to secure the proper administration of justice and in order to protect the interests of any person. And that, we say, essentially reflects the court's common law inherent jurisdiction. And such an order can be made at any stage of proceedings, regardless of whether there has been an earlier hearing in open court and whether the party seeking anonymity's name has been previously disclosed in open court, for instance, by way of pleadings. So no, my lady, I don't simply accept that next statement in the judgment of the learned judge below, because it's clear from once you go to the purpose of inherent jurisdiction, which is to regulate your proceedings, you don't do that in a fettered way.
But it would be a forward-looking order.
It could be. You'd say it could be forward-looking, but it might, depending on circumstances, it might not necessarily be forward-looking. It may be backward-looking one.
It's less intrusive if it's forward-looking than backward-looking. I don't think there is a barrier to the jurisdiction to make a retrospective order as well as a prospective order, but I don't press hard on the facts of this case for a retrospective order, as shown by the draft order, which we coloured in blue, those parts which could be included or could be taken out, which would give it retrospective effect.
So, is there a draft order you're seeking to ask this court to make? And if so, can I have the reference to it?
Yes, my lord. It's in the core bundle and it comes immediately after our...
It's a bit different from the one that was before Mr. Justice Nicklin, wasn't it? The
Yes,
application one was the
yes,
sort of
I mean,
pretty standard. This one's
it's a little bit
changed.
different, and if ever a case is developed, it's this one.
Oh.
It
Sorry,
may
where is
even be
it?
developing with the court.
Mr. Ware, just before you
Yes, my lord.
discuss it, could you tell me where it is?
Core bundle, page 55. my
When
lord.
you say core, do you mean core open or core closed?
My lord, I've only given myself, otherwise I think I would go batty. I've only given myself the closed bundle.
The closed bundle.
Might be closed one, my lord, because I'm looking at everything.
I think that the pagination should be the same.
Well, I'm very grateful if it is. I'm afraid I haven't
Well,
laboured to...
I did give a direction to that effect in the hope that we wouldn't get this confusion that sometimes occurs.
Yes, my lord.
When you have different pagination in different
That's
ones. So
extremely
I haven't
helpful.
actually checked, but I think it probably has been done.
It
Thank
is.
you.
I have now checked.
Good.
There's
Good.
page 55 and following, my lord. And if you go to page 56, for instance, when you see whereas little 2, any further publication, and it's in blue, Lordship can see that, I think. In paragraph 3, it's ordered that there shall not be disclosed in any report of these proceedings or other publication from the date of this order. And then a sort of, for the avoidance of doubt, paragraph 5. It's quite hard to read in blue, actually, but these restrictions do not apply to any publications lawfully made before the date of this order. But the actual submission I'm keen to make at this stage is 1 under the inherent jurisdiction and 2 under CPR 39.24 look at the language. There are no fetters because the circumstances in which the court considers it necessary to make, for instance, a withholding order are many and various. And what the court has not done is constrained or fettered itself in the application of that inherent jurisdiction. And there is nothing in A and BBC to suggest any such limit on the court's general power to make a withholding order. And
Are you going to show us BBC?
I beg your pardon, my
Are
lord.
you going to show that case so that we can see the facts?
Yes,
and
my
see
lord.
that there's nothing in it.
Yes, my
that
lord.
fetters the
I will
jurisdiction.
yes, my lord. I will show you now. I will start the A and BBC. My lord, if you kindly go to page 598 of the authorities bundle. It's 4.15 for my lady.
4.2.
Page 5. No, that's the tab, my lord. I don't think your lordship's relying on tabs.
Is it 522?
598.
Thank you. Yeah. Okay.
Your lordship can see from the head note, page 598F, that the petitioner, a foreign national, arrived in the UK as a visitor, married, granted indefinite leave to remain. 1996, he was convicted of sexual offences against his stepdaughter, sentenced to 4 years imprisonment, and the Home Secretary then served a notice of intention to deport him. And if you then go on to the judgment of Lord Reed at 605, we've sidebarred paragraph 2, as your lordship can see. The appeal brought by the BBC, well, I'll just let your lordship read that if I may.
Yes.
And then if you go on to paragraph 9 at page 607, you'll see there was an appeal through the tribunal system, which itself anonymised the name of the applicant.
Yeah.
And the applicant's case was, you can't send me back to my home country and disclose my name because I'm at serious risk of being hurt on account of the offences which I've committed in this country. Hence the application for anonymity.
Yes.
And if you then go to down to paragraph 11, you'll see the permission, the appeal was refused, and paragraph 12, A then applied to the Court of Session for judicial review. The petition was lodged on the 21st of September 2012. And paragraph 13, the application for interim suspension came before Lord Boyd on the 7th of November 2012, together with an application to amend the petition by deleting his name and address and substituting initials. And he allowed the petition to be amended. He also made an order under Section 11 of the 1981 Act prohibiting the publication of his name. So what we see there is that this is not a case in which the anonymity order, the withholding order, was made at the outset of proceedings. The outset of judicial review was on the 21st of September 2012. The withholding order and the reporting restriction order were made in November. None of this was a barrier to entry so far as concerned the Supreme Court when it analysed the case, and we're going to go to its analysis. But before we do that, you'll see down at paragraph 17, in the meantime, the BBC became aware of the order made under Section 11 of the 1981 Act and applied for it to be recalled, i.e. set aside. And if you go over the page, you'll see the Judicial Review Judge, paragraph 18, Lord Glennie, but you can pick it up below B. In these circumstances, Lord Glennie accepted it was necessary to allow A's name and identifying details to be withheld from the public in the court proceedings, and to make a Section 11 order. First, so as to safeguard A's convention rights, and secondly, so as to preserve the integrity of the court proceedings, since publication of that information would give A grounds for fresh application to the Home Secretary and frustrate the proceedings before the court. And then if you drop down to paragraph 21, the BBC reclaimed against Lord Glennie's decision to refuse to recall the Section 11 order, and also challenged his Lord Boyd's decision to make the order in the first place. Drop down, the court considered that. In any event, the recall of the Section 11 order would subvert the understanding on which A's deportation has been authorised. The present appeal is brought against that decision. So it's absolutely full square an appeal against both the withholding order and the reporting restriction order. We're then going to address the analysis of Lord Reed in relation to this. And he starts with the heading, paragraph 23, the general principle of open justice. It is a general principle of our constitutional law that justice is administered by the courts in public and is therefore open to public scrutiny. The principle is an aspect of the rule of law in a democracy. And can I just pause there, my lord? One of the points which has been, it's said, taken against us is that in relation to CPR 39.24, that can't operate to change the general law because its source is the Civil Procedure Act and it's relating, as the name suggests, to procedure. But that's not the way in which we put our case. The way in which we put our case was that the CPR 39.24 reinforces and confirms the scope of the inherent jurisdiction, which in our respectful submission incorporates, where necessary, not just a withholding order, but also a reporting restriction order. And we say that because it's perfectly plain that the principle of open justice is what I think, although it's a difficult territory to enter, is what I would describe as a substantive principle, like the law of confidence. See the seminal case of judgment of Mr. Justice Toulson in General Mediterranean and Patel back in 2000, just after the advent of the CPR. Paragraph 25, the principle that courts should sit in public has important implications for the publishing of reports in court proceedings. In Sloane and B, the Lord President, that's Lord Hope, delivering the opinion of the court, explained that it is by an application of the same principle that it has long been recognised that proceedings in open court may be reported in the press and by other methods of broadcasting in the media. In other words, exactly as Lord Reid says at paragraph 26 at the end, it follows that the principle of open justice is inextricably linked to the freedom of the media to report on court proceedings.
So where's that?
The end of paragraph 26, my lord, at H.
Yeah.
Page 610. Now, the importance of that, my lord, is that in just the same way that when a court makes a withholding order, it may very well want to make a reporting restriction order, because the two tend to march hand in hand. They are, as Lord Reid says, on both sides of the coin, inextricably linked. Maybe not in every case, but will in the vast majority of cases. And I think Mr. Justice Nicklin, I can't remember the paragraph number, but he himself set out that when making a withholding order, it will almost always be important to make a reporting restriction order because you're giving effect to the withholding order. Yes. That's the point. It's in that sense an ancillary order to give effect to a withholding order, because withholding orders can and frequently are made long after the name of the person whose name is now anonymised has been out there, put out there in the public domain. And to the extent that there is case law, and I'm grateful to the court for the additional case law provided yesterday, and I think it's a judgment of Mr. Justice Henderson, to the extent that Mr. Justice Henderson sought to indicate that there's a binary issue in and out the public domain, and that's critical. It's absolutely not the case. Not the case at all. We're going to see through A and BBC that we're engaged ultimately in a balancing exercise. It is not a binary activity like that. Bad luck. Your name was on the pleading's open to the public, ergo, all hope of the court protecting the proper administration of justice is over. Just reflecting for a moment shows that can't be right. Court doesn't hamstrung itself in that way. It's not what it does. The next paragraph, my lord, paragraph 27, I'm still on page 610. Exceptions to the principle of open justice is the heading. Since the principle of open justice is a constitutional principle to be found in the common law, and just pausing there, this is important because we're going to see reference to the common law later. It is not the parens patriae jurisdiction, and I didn't make my submission I was going to make earlier, that the parens patriae jurisdiction is equitable. That's set out in clearest terms in Abassi. The principle of open justice is found in the common law. So too are what Lord Reid describes as the exceptions to the principle of open justice. because he says, since the principle of open justice is a constitutional principle to be found in the common law, it follows that it is for the court to determine its ambit and its requirements, subject to any statutory provision. The courts, therefore, have an inherent jurisdiction to determine how the principle should be applied. That's a bit of an echo of, or at least it came before in time, but I think Lady Hale said something similar in Cape and Dring, albeit in a different context of applying for documents. But you're not in a binary world, you're in a world of contours, and working through those contours is part of the inherent jurisdiction. And the contours include what are called qualifications or exceptions. And the reason for that is given because we're now right in the heart of trying to answer the question that this court posed: why do we say this is how the inherent jurisdiction operates? And it's given by dropping down at paragraph 29 to a quote from Viscount Haldane, Lord Chancellor, in a seminal case of Scott and Scott, in which Viscount Haldane at G2H says, as the paramount object must always be to do justice. The general rule as to publicity, after all, only the means to an end, must accordingly yield. But the burden lies on those seeking to displace its application in a particular case to make out that the ordinary rule must as a necessity be superseded by this paramount consideration. The question is by no means one which, consistently with the spirit of our jurisdiction, can be dealt with by the judge as resting on his mere discretion as to what is expedient. The latter must treat it as one of principle and as turning not on convenience but on necessity. And again, to the extent that there is case law, and I hope my Lord or Justice Warby will forgive me if I say one of the cases that involved my Lord, to indicate that it's comparable to a discretion. It is not comparable to a discretion. It is the issue of whether a restriction on the principle of open justice should occur in a given case. It is a binary issue. There's a right-wrong answer to that. That's not a discretion and then standing back and respecting the discretionary ambit of the first instance judgment or something of that nature. That's not in our respect.
Where did I say that?
Well, I think it was in a divisional court case that one might construe it in that way, but one might not, my Lord. But in any event, it matters not.
I was surprised if that was the right way.
Well, it was in a division. It was in.
I get your point.
I've probably
Your point is
misconstrued.
on a principle, not about
I've probably
what I said.
misconstrued, my Lord, that which I read.
Anyway, we're in the court of appeal.
That's in our respectful submission anyway, the position. And there is a paragraph I can just give you the reference to. The court will have noted that there was practice guidance interim non-disclosure orders from Lord Neuberger, which is in 3.1 of the authorities bundle, page 124. Paragraph 11, that's page 124 of the authorities bundle. The grant of derogations is not a question of discretion, it's a matter of obligation, and the court is under a duty to either grant the derogation or refuse it when it has applied the relevant test. We say that's all of a piece with that which Viscount Haldane recognised back in 1913. And the same point was made forcefully in paragraph 30 in a case called In Re K, Infants.
So have we finished this A versus the BBC?
No, my Lord, not at all.
So where are we?
I do apologise. Back to page 611, please.
Yes.
We were at paragraph 29, my Lord.
Right.
I'm now at paragraph 30.
Right. Thank you.
And this is a reference to In Re K. And Lord Devlin, and the quote from Lord Devlin is at page 612B to C. Does your Lordship see that?
Mm-hmm.
But a principle of judicial inquiry, whether fundamental or not, is not only a means to an end. If it can be shown in any particular class of case that the observance of a principle of this sort does not serve the ends of justice, it must be dismissed. Otherwise it would become the master instead of the servant of justice. And again, you'll see Lord Devlin at D, it must be shown it's a matter of necessity in order to avoid a subordination of the ends of justice to the means. None of this we take issue with. This is the right test. paragraph 32, you see Lord Reed identify that it's been recognised in English case law consistent with Lord Neuberger's requirements of degree of privacy being kept to a minimum, that where the interests of justice require some qualification of the principle of open justice, it may not be necessary to exclude the public or the press from the hearing. It may suffice that particular information is withheld. So just going back to that sentence.
Sorry, I've lost my place.
Yes, my lady. It's
Where's
page 612 at G.
Thank you.
612.
Got it.
And that's an important sentence, where the interests of justice require qualification of the principle of open justice. This is all of a piece with what we've seen at paras 29 and 30. And then the court is identifying, the Supreme Court is identifying, that you can have a lesser qualification than excluding the press from the hearing, because you can have an anonymity order. So in Attorney General and Leveller, for example, Lord Diplock accepted where the court might sit in camera in order to preserve the anonymity of the witness in the interest of national security. It could instead allow a much less drastic derogation from the principle of open justice, namely that the witness should give evidence in public but should be permitted to withhold his name from the public and the press. And so, again, we see, if you then kindly go over to page 613, paragraph 34, essentially the same point being made and the theme being brought together, para 34, the common law power to make exceptions to the principle of open justice in the interest of justice was recognised in a case called Sloan and B. So it couldn't be clearer. What lies behind the principle of open justice is the doing of justice or the interests of justice. This is all an aspect of the common law. It's not the common law equals open justice and you're somehow seeking to bash the common law. It's part of the common law that it is qualified, or there are exceptions to the principle of open justice when it's necessary for them to be so. And we're now going to see at paragraph 35 classic circumstances in which it is necessary for there to be so. So paragraph 35, am I going too fast with order? Page 613. It's also been recognised in Scotland that the qualification of the principle of open justice, which is necessary in particular circumstances, may not require to be as drastic as the complete exclusion of the public or the media from the proceedings, and that less extreme measures, such as the protection of the anonymity of a witness, may sometimes suffice. He then references a case involving the confidentiality of documents, and I'm going to drop down, this is one where that it was needed for there to be some withholding of information, and then drop down to G. The case was therefore one in which a limitation of the principle of open justice was necessary, both to protect confidential information and to prevent the frustration of the judicial process.
Yeah, well, that's a simple case, isn't it, where if you open it all up, you defeat the whole purpose of the litigation.
Absolutely.
That's not this case by any stretch.
Oh, my lord, I will make a submission.
Yeah,
it's not this case, my lord. It's not this case, but we're looking at jurisdiction. We're not looking at that's an easy case, this is a harder case. We're concerned with what the Supreme Court's analysis does. Lord Reed starts with the principle of open justice. He recognises that it is a part of the court's common law inherent jurisdiction to determine its qualifications as well as to uphold the principle where appropriate of open justice. It then explains, and this is critical, that securing what I describe as the proper administration of justice, for which read another series of descriptions including preventing the frustration of the judicial process, provides, where appropriate, where necessary on the facts of a given case, provides a justification for qualifying the principle of open justice. Hence my submission at the outset that there are these twin related limbs when you are engaged in the conduct of proceedings, because the court is seized of the action and has what I might colloquially describe as the muscle through this common law inherent jurisdiction to ensure that justice is achieved. It doesn't need to go to its equitable parens patriae jurisdiction in this context. It is part of the civil litigation process. And then my Lord, Lord Reid describes at paragraph 38, as I've explained, it's long been recognised the courts have the power to permit the identity of a party or witness to be withheld from public disclosure where that is necessary in the interests of justice. The Lord President was plainly right to approach the matter on the basis that the interests of justice are not confined to the courts reaching a just decision on the issue in dispute between the parties. It's necessary in the first place to recognise that the administration of justice is a continuing process. See, for example, AGM Butterworth. And AGM Butterworth is the decision that was referred to by Lord Widgery in the Socialist Worker case. And that was a passage that no doubt the court was keen that we acknowledge, and indeed so clearly is before the court already, and that's an important passage. The court can therefore take steps in current proceedings in order to ensure that the interests of justice will not be defeated in the future. And Lord Reid gives an example of permitting undercover officers to give evidence so as to ensure that they can perform their future investigations. And in Butterworth, it was about, I think, ensuring that a person who complains about, I think it was blackmail, it wasn't just the person who's complaining, it was so that people in the future will bring their complaints of blackmail and their name can be anonymised. In other words, the administration of justice is construed broadly in this context. Lord Reid then brings it together. I don't wish to miss out parts, I'm just trying to go to the parts that, in our respectful submission, the most important. At page 615, paragraph 41. The examples given by the Lord President of a party or witness whose safety may be endangered or may suffer commercial ruin if his identity becomes known, or that of the female pursuer where the decision turns on intimate medical evidence, are all capable of raising issues which could warrant a qualification of the principle of open justice, applying the approach which I've explained. In relation to the last example, which is subject to particular criticism by counsel for the BBC, I agree with the Lord President it would be in the interest of justice to protect a party to proceedings from the painful and humiliating disclosure of personal information about her when there was no public interest in it being publicised. Whether a departure from the principle of open justice was justified in any particular case, and here is the test, would depend upon the facts of that case. As Lord Tolson observed in the Kennedy case, the court has to carry out a balancing exercise which will be fact-specific. Central to the court's evaluation will be the purpose of the open justice principle, the potential value of the information in question in advancing that purpose, that's on one side if you like, and conversely, any risk of harm which a disclosure may cause, two, the maintenance of an effective judicial process or the legitimate interests of others. And again, if you then go back to 39.24 of the Civil Procedure Rules, essentially that's being echoed in the terms of CPR 39.24. And this is Lord Reid, as we'll see, where there's a section on convention rights, which I'm going to go through. There's a section on the Contempt of Court Act, which is important. And then when he gets to the case, he just addresses the case, applying this balancing exercise. And he does not distinguish at that point, when addressing a case, between the reporting restriction order and the withholding order, in the sense that he upholds both. But applying this test, which is a test which he's sought to explain, comes under the inherent jurisdiction of the court, albeit it happens in that case that the order made at first instance for the reporting restriction order was made under Section 11 of the Contempt of Court Act. So I might actually park the section, well, I can probably do it quickly. I'll do it quickly now. The section on convention rights is to some extent being superseded, or at least explained, by the Abbasi case. So things have changed, and INRIES's position has changed, and I'll go back to INRIES in due course. But for these purposes, I think it suffices to go to paragraph 54 on page 619. Paragraph 54, can I just invite the court to read that paragraph, please?
Yeah.
Yes.
So that's Lord Reid saying you can do it under convention rights, but actually you're applying essentially exactly the same test I've just sought to set out at paragraph 41. My shorthand. And that's, my Lord, and forgive me for leaping in at paragraph 55 early doors, but that's the context, my Lord, for paragraph 55, which is the next one that follows under the heading of the relationship between the convention and domestic law. And that's Lord Reid saying, I'm not concerned with a case like in Re S, which is seeking an order contra mundum restraining publicity relating to court proceedings. I'm concerned with the conduct of court proceedings. And so at paragraph 57 between B and C, Lord Reid continues, as was made clear in Kennedy's case, that's the one he referenced when setting out his test at para 41. However, the starting point, this is page 620, my Lord. The starting point in this context is the domestic principle of open justice with its qualifications under both common law and statute. Its application should normally meet the requirements of the Convention, given the extent to which the Convention and our domestic law in this area walk in step.
Sorry, you were reading from where?
57, my Lord, at page 620 between B and C.
Thank you.
I'm going to dip out of the part on section 11 of the Contempt of Court Act, that logically comes later.
Just before you do, forgive me if it's a daft question, but para 55, I'm not quite sure I've got the distinction that's being made there.
Yes, my lady. Can I do it by...
Could you just put it in ordinary language? What's he juxtaposing? Two different sorts of...
I might do it by reference to in Re S, my lady.
Can I just have words?
Yes, of course you can.
Just describe it to me.
Yes, my lady. Yeah. Someone can say the following. Something's happened in open court. I really don't want people to know about this. I apply to the court for a contra mundum injunction in relation to those court proceedings seeking a reporting restriction order. That's what I describe as a Venables type case.
Is that a third party?
It could have been a party, my lord. In fact, for instance, after the proceedings, it could even be before the proceedings, because in Re S it happened before the proceedings. It happened before the criminal trial. In Cuja it happened after. It doesn't matter.
So why is paragraph 3, I think, I can't remember, of your draft order not such an order?
My lord, to the extent that para 3 of our draft order doesn't meet with this, and it needs to be superseded, because this is the submission I'm seeking to make is the submission I want to be held to, not the draft order, to the extent that it doesn't mirror, as it obviously should do, but doesn't mirror exactly my submissions now.
Well, but it seems to me the effect is the contra mundum injunction if you have a situation where material is in the public domain, you make a withholding order, and you then make an order restraining the press from identifying any material which could identify the claimant in the future. That is an injunction. Press is the world for this purpose. And what I don't really understand is why that automatically fits in to what Lord Reid is talking about, namely the control of your own proceedings, derogations from the principle of open justice, as opposed to a contra mundum injunction. I mean,
because my lord,
you know, when we come to Cuja, Lord Sumption makes it perfectly clear that that latter thing can only be done where it's warranted by statute.
That could... Let me park Cuja for the moment, because I want to deal with Cuja fully in one go, if I may. But I well understand, my lord, that the effect of an order is comparable to the effect of a contra mundum injunction. But the source of the jurisdiction is the issue before the court at this stage. And there is a distinction which Lord Reid very clearly draws between the powers that the court has, the inherent powers it has, when it is seized of an action, because it is managing its own proceedings.
Well, if that's right, then I don't see why you didn't accept what I asked you, which is that it would be different if the application or the contra mundum injunction were made by a third party. So I completely understand that you might need a different jurisdictional foundation for a third party to ask the court, for example, a witness, to ask the court, maybe not a witness, but a third party to ask the court for an injunction against all the world not to disclose something that has been said in court. But it seems to me that if the party is asking for such an injunction, you have to say that's different because it's part of the process of the court.
My Lord, the reason I'm reluctant is I'm just trying to find it. I'm pretty sure that in the relevant section of Lord Reed's analysis, which essentially kicks off at paragraph 27, he gives us an example anonymising a witness, his name, and this is all part of his analysis of what the court does to manage its court process. So respectfully, I don't consider that that is the key distinguishing feature.
Right.
The key distinguishing feature is that which Lord Reed has adverted to. It is between a case, a court seized of a case. At that point, you have multiple obligations, but one of your key obligations is to secure that justice is done. And your inherent jurisdiction in those circumstances permits you to make a wide range of orders as are necessary in order to secure that justice is done. Some of those orders will be injunctive, and I suppose it could be described that when you make, the invention of the Anton Pillar order, the Morava injunction, and so forth, these are courts securing the proper administration of justice, because otherwise the order that you would subsequently make would be frustrated, and that's how the court has shown itself that it has this inherent jurisdiction. That is completely different from somebody saying, so what happened in Ries is that the mother was due for trial for murder of her child. The deceased child's sibling, in advance of the criminal trial, made an application, I think, to the family division of the High Court for a contra mundum reporting restriction order. It was not seeking to change that the proceedings would occur in open court in the criminal trial. It was simply seeking to say, I don't want the press to report my name. And so I am seeking, the only remedy I'm seeking is this, a reporting restriction order. It's exactly materially the same as Cuja, and that is completely different. That's paragraph 55, my lady.
Thanks for that.
It's a goldmine, this judgment, in terms of the analysis. It's all kind of all there in our respectful submission. And then what
It
you...
wasn't just the name of the child that was sought to be enjoined in Ries, it was also the name of the defendant and the deceased child, because otherwise
because
there
of
would have
the
been
jigsaw, etc.
identification.
Yes, but it's
So
reporting...
quite an intrusive order that was
Yes, it was.
sought so far as pre-reporting of court proceedings is concerned.
Yes, indeed, my lord. Giving rise to different issues, and of course all these cases give rise to different issues, and I'll come back to that when we get to the facts of this case in due course, but they are giving rise to different issues. For these purposes now, I'm really just going to reference the page 623, starting at para 69, Lord Reed continues the present case, and there he analyses the case on the facts. And what he does, if you start at paragraph 71 at H, is Lord Reed notes it's also true that A has in the past been the subject of publicity in which his name and photograph were published. It's also undeniable that although BBC could report all other aspects of the case, their inability to reveal A's identity would detract from the human or journalistic interests of the story. And that addresses, in short order, 2 of the 5 issues that the court asked be addressed in oral submissions today. That is, what's the relevance of prior publicity and what's the relevance of a name? The name is relevant, no question about that. It impinges to some degree on the journalistic interest of a story. That's highly fact-sensitive, but as a matter of generality, that's right. But there is no barrier to entry to an anonymity order, and there's no barrier to entry based upon past publicity. And in this particular case, paragraph 73 really turned upon needing to maintain or secure the proper administration of justice. And you see this at paragraph 73. In that situation, the publication of A's identity or of information enabling him to be identified would have subverted the basis of the tribunal's decision to authorise his deportation. That decision had been based on an assessment that there was no real risk of violation of Article 3 if his identity was not publicised in connection with the deportation proceedings. The decision would have been undermined before the challenge to its validity was determined if his identity was published in the meantime. Drop down to E. The publication of A's identity would therefore have frustrated the judicial review proceedings before the court. Indeed, the entire proceedings since at least 2007 would have been rendered largely pointless. And that was sufficient to address both aspects, because down at paragraph 76, it also follows...
Why is that not the ratio of the case, really? Isn't that really what he was deciding? That this was a simple case of where you anonymise and injunct to prevent the whole purpose of the case being subverted.
My Lord, in terms of the ratio of a case, there's guidance from, I can't remember if it's Lord Legate or Lord Justice Legate. I can't remember the name of the case now, but Lord Legate / Lord Justice Legate gave guidance, which I understand to be generally accepted, that you do not construe a ratio narrowly. You look to understand the full basis upon which the court has reached its conclusion. I think in circumstances in which you have the President of the Supreme Court, or not, maybe not then, he wasn't then the President, but the Supreme Court giving a unified judgment in relation to this issue, in which one can track so clearly the incredibly careful analysis of Lord Reid as he gets to the conclusion he reaches, it would be quite inappropriate to treat this as a case which is limited to the facts of, well, that's a strong case on the facts, so ergo we're done.
Well, no, arguably the reason the ratio is, at least includes the proposition that it would defeat the purposes of the proceedings, which is the narrow basis that we talked about earlier in relation to confidentiality. Arguably it also includes the reasons given at 74, which is a risk to the Article 3 rights of A. It's the same point in another guise. Pointless to deport him because he'll otherwise be subjected to torture.
Yes, my Lord. But how Lord Reid doesn't get there.
Look at these cases by reference to their facts, not necessarily confining the decision of principle to the facts of the case, but they're not completely adrift from their facts.
No, my Lord.
And so you would have to say this principle should be taken and applied to a case where no one suggests we've got Article 3 rights engaged. We're talking about other kinds of rights. We're talking about threats to financial interests and threats to private life. Is that right?
Oh, absolutely, my Lord.
Yeah. So the broad statement that you have offered us, that it's in the interests, the court has power whenever it's in the interests of justice.
Yes, my Lord.
Depends on quite a broad conception of the interests of justice. It goes beyond actually being able to decide the case. It goes beyond being able to decide fairly other cases,
yes,
other aspects of the same case, as in the example of PQ. It extends to private interests or rights, some of which may be protected by the Convention. But we're bringing in conventional rights.
Absolutely.
Yeah.
Absolutely. I mean, Lord Reid is only able to make this assessment because he's taken himself on a journey to a balancing exercise which he's then conducted. He's explained how he's reached his balancing exercise in the passages which I've sought to take the court through, starting with the heading Open Justice, then exceptions to Open Justice, ending up with his paragraph 41. That is undoubtedly, in my representation, a part of the ratio of the case. That question.
But
part of his reasoning. It is his reasoning. It's the core reasoning that takes him on his journey through a balancing exercise.
I'm sure I see a balancing exercise in 74.
Yes, my Lord. It's my fault because I've sought to sort of, if you like, possibly rush this part, but that's why he sets out at para 71 features that support the BBC's contention, and then he says at para 72, nevertheless, That's his balancing exercise. But forgive me, I would simply have to invite the court to read it in toto, this section later, just to see that is exactly what's happening. There is a classic balancing exercise. He has to make...
I mean, jurisdictionally, what is at stake here is everybody acknowledges there is a jurisdiction to make a withholding order. Everybody acknowledges once you've made a withholding order, you can make a Section 11 order, which gives statutory jurisdiction to make a reporting restrictions order. So jurisdiction, what's really at stake in this case is when you have not made a withholding order and material has gone into the public domain, is there, and therefore Section 11 doesn't apply if the judge is right, you may have a different view.
That's just not right, so I'll have to come back to that.
Not right. I mean, it is right if there's no withholding order. Section 11.
Yes, you need a withholding order, but it matters not when the withholding order is made.
Right. Okay. But let's assume that's the case, and that's what jurisdiction is at stake. Is what is the jurisdiction when no withholding order is made, because this particular cat is potentially out of the bag already in relation to this case, so that the press has published articles identifying.
My lord, that's not our case, respectfully. We are seeking a withholding order and a reporting restriction order.
No, I know you are. I'm trying to see what is the effect of your submission. Your submission is that jurisdictionally, the court has carte blanche to make any order necessary to derogate from open justice in order to achieve the ends of justice and the proper administration of justice and its procedures, right? What's said against you is that Cuja makes it clear that you need a statutory foundation for making a reporting restrictions order of what has gone on in court, because that is a muzzling of the press, censoring of the press, and Section 11 doesn't apply here for the reasons I just gave. So that's what's in issue. I'm trying to work out what's in issue, and your answer to that is that this very, very broad inherent jurisdiction covers anything in the context of the ongoing proceedings. And when we look at the kind of case, A and the BBC is a case where, of course, one might say the inherent jurisdiction allowed such an order to be made because, as CPR Part 39 reflects, if you're going to frustrate the very purpose of the order you're making, of course you can make an injunction to restrain that happening. I mean, freezing injunctions are made every day, and they're held in private, and no doubt often associated with injunctions. So what I'm trying to get to is really the sort of nub of this argument is, does A and the BBC go so far as to cover a case where it is simply desirable to injunct publicity about what's gone on in the court, as opposed to necessity? Because you say it's desirable, you say very desirable, you say this is a very vulnerable person who's going to be damaged and so on, but question whether that is a matter of necessity.
Lord, part of that observation, Lord, involved whether it's desirable of things that have gone on in court. It's not things that have gone on in court. It's subject to my submission that, if the court was so far with me that it was minded to make a retrospective order, there is jurisdiction to make it. Our essential case is a prospective order, so it's not accurate to describe our case as we're seeking to withhold that which has happened. We are seeking a withholding order, and just like the language of Section 11 of Contempt of Court, ancillary to that, to give effect to it, a reporting restriction order, going forwards in relation to matters which have yet to be disclosed.
Well, yes, but that would, your order would it not, prevent a putative publisher from republishing an article that's already in the public domain.
Correct.
Yes.
Absolutely.
So it's not
Or
entirely
hyperlinking it. The old one.
forward.
Or would they have to take down what's already there?
No, my lord.
But that's continuing publication. So anything that happens in future, everything that's already been published, I think, if you draw a line at the point when the order is made, everything that's already on the internet has to be reviewed.
That's perhaps why we've drafted. Maybe this part of the draft is of some value. The part that said, for the avoidance of doubt, that which is already out there can stay out there. This is about.
Well, the standard way of doing that is the public domain proviso, which is in the model order in the INDA guidance, as I call it for short, Master Rules guidance. And then if that was introduced, then the court would have to consider whether there was any point in making a reporting restriction order that was so limited that it didn't impinge on. I mean, that was part of the judge's thinking, wasn't it?
This is getting to ground two.
I understand that.
Can I park ground two for the moment, because the sense that we're seeking it because it's desirable is, we would respectfully submit, an unfair characterisation of our case. It's necessary in this case, and we accept that the test is one of necessity. Can I now turn, please, to the Wolverhampton judgment? So it's page 1100, 1100, it's 4.31. The court will know about this judgment. This is the case in which, as set out in the Bassi, the Supreme Court conducted a wide-ranging review of the court's powers to make contra mundum injunctions, and gave, put it this way, definitive guidance in relation to the same in incredibly detailed judgment. If you go to page 1100, paragraph 32, you see in the heading, injunctions to protect human rights, and you see reference to the Venables case. And that is what we say is an example of freestanding Venables injunction. That's the you have to bring, as Bassi seeks to explain, I can go to Bassi in due course, you should bring your domestic cause of action, which was then identified as breach of confidence and now would simply be the tort of privacy, in order to seek the remedy before the court of your contra mundum injunction. So that's paragraphs 32 and 33. Can you then go down to paragraph 34, please, headed Reporting Restrictions? Reporting restrictions are prohibitions on the publication of information about court proceedings directed at the world at large. They are not injunctions in the same sense as the orders which are our primary concern. And that's why, my Lord Master Rolls, I'm reluctant to say this is just a contra mundum injunction. It's not. It is an injunction relating to, arising out of court proceedings, and it is materially different. But they are relevant as further examples of orders granted by courts restraining conduct by the world at large. Such orders may be made under common law powers, or may have a statutory basis. And with the greatest respect to the learned judge below and all of my colleagues, no one has provided me with an answer to my reliance on this other than say it's obiter dicta. In other words, Lord Reid is wrong. Lord Reid is not wrong. Lord Reid well understands what he is saying here, and having gone through A and BBC, we can understand why, because he has identified in A and BBC that there is a common law inherent jurisdiction, not just to support the principle of open justice, but also, where appropriate, to qualify it.
So you place great reliance on paragraph 34 because it refers to common law powers.
Absolutely. I say great reliance. I place great reliance on A and BBC. I make no bones about that whatsoever. No bones. And I simply say that that which Lord Reid said with Lord Briggs and Lord Kitchen in Wolverhampton does no more than confirm his analysis in A and BBC. So it is not odd, unusual, or wrong.
Could we just see where A and BBC is referred to
Yes, it's not. It's not. It's one It's a one-hit wonder. One paragraph, para 34, because he's flagging up. This is. It's not. It doesn't reference A and BBC. It's my submission to the court.
Was it cited?
Not referred to. Yes, my lord. Page 1081. Furthermore, over the page 1101, paragraph 35, embargoes on draft judgments. It is the practice of some courts to circulate copies of their draft judgments to the parties' legal representatives, subject to a prohibition on further unauthorised disclosure. The order therefore applies directly to non-parties to the proceedings. Like reporting restrictions, such orders are not equitable injunctions, but they are relevant as further examples of orders directed against non-parties. Now that, in my respectful submission, is a very interesting example of a reporting restriction order without a withholding order. Because that's what an embargo is. Don't report it, but I'm not going to anonymise the names.
Well, the withholding, assuming the embargo is an order, the withholding is don't disclose anything in this draft. So it's not focusing on names, it's focusing on the entirety
Absolutely.
of the information. So it's withholding, it's a withholding order if it's an order at
Well,
all.
it's a withholding / reporting restriction order. I would have thought. It's its own thing.
Well,
It's an embargo. It's got its own heading here. Embargoes on draft judgments. I would understand that as essentially a requirement that no one discloses it to the members of the press, and that's why members of the press would be in contempt of court if they were to report the judgment in draft.
And what would your case be on the jurisdiction for that proposition, that it's all part of the inherent jurisdiction?
That's the same. What we've done by way of shorthand here is Lord Reid identifies it's not an equitable injunction. That's because it's under the common law.
Which takes us back to inherent jurisdiction for
It's
case management
it's the inherent
purposes.
common law jurisdiction of the court to secure the proper administration of justice, and it's a paradigm for that. That's the court just doing what it needs to do, doing its job, per Lord Reid in A and BBC.
But it's within, I'm still struggling
Yes,
to find a way
yes,
to express it.
my
It's
lady.
within the confines of your proceedings
It's in
rather
the
than a
conduct
conjunction.
of proceedings. The proceedings are afoot there before the court. The court hasn't yet ceased its jurisdiction. It's not fructus at that point. It's fully seized of the case. It can do all sorts of exciting things at that point. It could even change the substance of its judgment were it minded to do so. Not this typographical errors. Not something that often happens, but it could do. So that is a classic for the conduct of proceedings. And either Lord Reid, Lord Briggs and Lord Kitchen have gone off on one, or this simply makes sense because it all ties in with the A and BBC judgment.
It doesn't really matter, does it, to you? Because you say there is jurisdiction to grant an injunction with or without a cause of action, see Wolverhampton, anyway.
If you are going back to the Venables scenario, then the core guidance in relation to that is set out, for instance, at page 1256. But it starts earlier. But we could probably pick this up. Probably best to pick this up at page 1252, please.
Of this case,
This is a Bassi. This is page 1252, paragraph 83 of a Bassi. As was explained in Wolverhampton, the court possesses an inherent and unlimited equitable power to grant injunctions, subject to statutory constraints. And then Lord Reid and Lord Briggs continue. That power is confirmed and restated in section 37 of the Senior Courts Act. And what I would ask the court to do there is note that's just, while we're on it, that analysis. It could have been said there had been an equitable, unlimited power, inherent power to grant injunctions, but it was superseded by Section 37 of the Supreme Court Act. But that's not what they say. And the continuation of all of the analysis is, let's look at what equity does in relation to injunctions, and you get detailed guidance as to how equity shapes the court's power to make injunctions. And we say, respectfully, exactly the same things happened with 39.24 of the CPR, and that's why we use the same language, that confirms and restates the inherent jurisdiction, but in no way removes it. And then Lord Reid explains at paragraph 85 that Section 6.1 doesn't confer any power on the court which it doesn't otherwise possess, that it's prohibitory, not enabling. And at paragraph 86, he acknowledges that the inherent equitable jurisdiction...
I missed that submission. Where were
My
you?
Lord, paragraph 85, page 1252. We're slipping a bit into Section 6 of the Human Rights Act, but it's just because we're in a Bassi now. Section 6 doesn't confer a power on the court which it doesn't otherwise possess, and that's why Lord Nichols had called it prohibitory, not enabling. It's based on the language of Section 6. And then over the page, at page 80, paragraph 86, Lord Reid says the court's inherent equitable jurisdiction is in principle sufficiently wide to enable it to grant an injunction when its failure to do so be incompatible with convention rights. Para 87, however, domestic causes of action are the means by which compliance with convention rights, including those protected by Article 8, is normally secured. At para 94, page 1255.
I mean, what? Okay.
I'm just seeking
what
to...
does that mean?
What it means, my lord, is that which we see set out at paragraph 98, page 1256. If you are bringing what I call a freestanding Venables application to the court where the remedy you seek is a contra mundum injunction, that's your only reason for being there, the ordinary proper approach is to assert, plead and evidence a domestic cause of action, normally the tort of privacy. However, para 98, confirming that which is set out at paragraph 86, says, so this is F, my lord, at page 1256, notwithstanding the general rule that parties should protect their convention rights by availing themselves of the appropriate cause of action under our domestic law, we do not rule out the possibility that there may be circumstances in which it will be proper for the court to exercise its broader equitable jurisdiction so as to ensure that the protection afforded to convention rights is practical and effective. And that is very much of a piece, my Lord Master of Rolls, with my Lord's observations in Tickle. I mean, it was a...
So you draw a bit of a bright line distinction between the equitable jurisdiction reflected in Section 37, to which Wolverhampton was primarily referring to, and the common law inherent jurisdiction of the court to protect its own process. I can put it that way.
I do, my lord, and that's again when one goes, and it's why when we eventually get to go,
A bit unfashionable after 1873, isn't it?
Well, my lord, I apologise, and your lordship's association with the law of equity notwithstanding, this is the position, my lord. I'm very happy to
only
here to follow the guidance that the highest court in the land has given, my lord, and this is that guidance, and that's why if I just revert once again to page 619, para 55 of AMBBC, now going back to it and apologise for sort of throwing it at the court early doors without this build-up. Page 619. So in res is your freestanding application by the child. And Lord Reid says, these dicta were not, however, concerned with the conduct of court proceedings. They concerned a different issue, namely the jurisdiction of the English courts to make, and I would add in now, equitable contra mundum injunction orders, so the words orders contra mundum, restraining publicity, relating to court proceedings. In other words, these court proceedings have happened or about to happen. I just want my contra mundum equitable injunction. That's something quite different. That's a Bassi Part 2. Bassi Part 1 is the best interests hearing, when the child is alive, a bassi part 2 is your contra mundum equitable injunction, in which the guidance given is generally plead your domestic cause of action. That's all very different from the common law inherent jurisdiction to make such order as is necessary. See the words of I think it was Lord Hope in BBC that my Lord Master Roll described as pretty sort of open-ended, and your Lordship's obviously right. So
Which page?
that was the that was page 439, my Lord. We go back to that.
Yeah. I mean, the elephant in this particular room may still be Cuja.
Well, I'm delighted to be getting on with it shortly, my Lord. Now may be even the time for me to attack Cuja. And not so much attack it as respectfully seek, we would say, to explain it. It's not a question of attacking it.
Well, I mean, you have to be aware that, of course, Lord Reed was, I don't know whether he just agreed with Lord Sumption, but he was in the court.
He was, my Lord.
Yeah.
Yes. So 439 was between G and H, Lord Hope saying the House has an inherent jurisdiction to make such orders as are necessary for the purposes of the proceedings which are before it. That's the conduct of proceedings. Lim, as opposed to the contra mundum injunction, lim, if I can put it that way.
Have we dealt with Wolverhampton now? Have we done Wolverhampton, or is there more to do?
We have, my lady. So can I now go to the Cuja judgment, which starts at page 758, 4.21. I've already set out some of the facts, but if you kindly then go to page 768.
Sorry, you said 700 and...
It starts, my lord, at 758 for your note, but I'm going to take you, please, to page 768.
Yes.
So, my lord, paragraph 4. This is the individual who was arrested, bailed, and then de-arrested, as you see from paragraph 4, in relation to an operation designed to capture people involved in sexual offences against children. And unsurprisingly, the person, Cuja, did not want his name attached with them.
No, but the important sentence is the last one. The position of the two newspapers is they wish to publish this information identifying PNM, but what they publish about those matters will be confined to material derived from the proceedings at the trial.
Exactly. Exactly, my lord. So what happened is, as you see paragraph 6, at the trial, starts paragraph 6, at the trial, evidence was given, and then we see that PNM was referred to on a number of occasions, because if you go over the page 769 at the top, subsequently PNM was referred to on a number of occasions. This is between A and B. A police officer gave evidence that PNM had participated in an identity parade but had not been identified. There was also evidence referring to PNM's involvement by at least one of the defendants. In their closing submissions, both prosecuting and defence counsel referred to Legend X on the footing the complainant had been referring to PNM, identifying him by his full name.
And none of that was reported because there was a reporting restriction under Section 4,
Well,
Subsection 2 of the Contempt of Court Act.
That's paras 9 and 10, my lord, in which he proposed to lift the order. So that's a reporting restriction, not a withholding order. which was temporary. And so what you've had is you've had disclosure in open court of information here, the name and association of P&M with the case. But there has been no withholding order at all. And if you go to paragraph 16...
Except when you got to the case, because they must have given a withholding order for him to be called P&M for the course of the case.
Well, my lady, what I'm going to do is read out paragraph 16, which I think that's just something that's been held over from, no doubt he was referred to as P&M in the judgment until it was decided that...
Yeah, but that must have, it may not matter,
would
that
go
must have been on the back of somebody's direction.
Because when we get para 16, my lady,
Yeah.
we get, after reference to the principle of open justice, we get the distinction between these two aspects is not always recognised in the case law, but some importance in the present case. There's no issue on this appeal about the way in which the criminal trial and the applications under section 4.2 of the Contempt of Court Act were conducted. Judge Rook, QC, sat in public throughout. All of the relevant matters were disclosed in open court. No measures were taken to prevent parties or witnesses or those referred to at trial from being identifiable for those members of the public who exercise their right to be present in court. This appeal is concerned with the question whether matters exposed to the public criminal trial may be reported to them in the media. It's been recognised for many years that press reporting of legal proceedings is an extension of the concept of open justice and is inseparable from it. That's an echo of Lord Reed in AMBBC. And so what we have there is an open justice hearing in which the applicant is saying, I do not want you to report that which has been disclosed in open court. And that is the Venable's freestanding style scenario. So it carries on, if you go over to page 773, after the quote, for this reason, restrictions on the reporting of what has happened in open court give rise to additional considerations over and above those which arise when it is sought to receive material in private or to conceal it behind initials or pseudonyms in the course of an open trial. Arrangements for the conduct of the hearing itself fall within the court's general power to control its own proceedings. They may result in some information not being available to be reported, but in convention terms, they're more likely to engage Article 6 and Article 10. Reporting restrictions are different. The material is there to be seen and heard, but may not be reported. This is direct press censorship. So this case involves an open trial in which the name is disclosed and an attempt after the event to gag the press, if you want to put it that way, or to censor the press, to put in a reporting restriction order. That is what Cuja is about.
So you say when it says reporting restrictions are different, that has to be read in the context of a sort of contraband and Venable style.
Yes, yes. And if you kindly go to Abbasi at page 1252, paragraph 83.
1212.
I'm just looking for my own reference now. Just
1252.
I thought it was
what you
para
said.
83, but it's
Yeah, 1252.
yes, but it's not. It's. I think I might have the wrong.
Oh.
I'm just looking for it. Sorry, that's it. Yes, sorry, it's paragraph 80. So paragraph 80, if you're kind enough just to sort of look back, you'll see that paragraph 79 is the clinician's cause of action in tort. This is what are these causes of action you should be promoting in your freestanding claim, and obviously the classic one is privacy. And then if you go to paragraph 80, that evolution, that's the whole development of the tort of privacy, began in cases such as Campbell and NGN with the development of the equitable action for breach of confidence. And then it carries on. I'm not going to read it all out, but if you sort of scan down, then get to E, you'll see in relation to all stages of analysis, guidance can be found in a rapidly growing body of domestic legal precedent, as well as in developments in other jurisdictions which share our common law tradition and in the jurisprudence of the European Court. The courts have also recognised that the cause of action is not limited to the disclosure of private information, but extends to other forms of invasion of privacy in such cases as PJS and CUJA. That's confirmation by the Supreme Court in Abbasi that CUJA is a Venables type, freestanding, contra mundum injunction case. That's how it should properly be understood. That's what it is. And because it's that, it's not even the case that there needs to be a statute, because you can express your domestic course of action in tort. That's what is explained in the passages I've referenced. Lots of other sidebar passages we've sought to highlight in the judgment. This flows into the paragraph 83 and following that I was reading out, which culminates in paragraph 98. But that's what CUJA is. And that's not because it's a witness or a person who was tied up, but not the criminal defendant. That's because this is separate from the conduct of the criminal trial.
Could, on your analysis, Judge Rook have decided that it was in the interest of justice and necessary to withhold the identity of PNM from the jury and the public at the trial?
Well, forgive me, just as you were saying now, just my rider to the statute not be needed is, of course, this is the Crown Court, and because it's the Crown Court, there was no inherent jurisdiction.
Well, we agreed earlier, I think, that your submission is that there's no inherent jurisdiction to make a reporting restriction order, but there is inherent jurisdiction to withhold a name where that's necessary for the interest of justice to be given effect. I thought we'd agreed that.
In the Crown Court?
In the Crown Court.
Well, I think your Lordship have made observations which I didn't actually really respond to, because I have not looked up, because that identified how the Crown Court doesn't have an inherent jurisdiction, stuck with that on the basis of being concerned with a civil High Court case. I'm afraid I didn't then go off and root around for other aspects of the Crown Court's jurisdiction.
Maybe a topic to come back to, but generally speaking, courts of limited statutory jurisdiction do have an inherent jurisdiction. It's very limited, but it is a jurisdiction to do what's necessary to perform the function that they have. I would have thought, following through your argument, that the Crown Court might have such a jurisdiction, and it could have been exercised in this case if it was necessary to give effect to the private life interests of PNM.
Well, forgive me, I can't really answer that other than say that I've taken you to the passages in IMRI Trinity and IMRI BBC, which would indicate that it's an inferior court, I think is probably the right description, which does not have its own inherent jurisdiction. After that, I would bow to this court in relation to its knowledge of the actual, what is left of the Crown Court, but it's not really germane in my respectful submission.
In your submission, essentially section 4 subsection 2 was the only way that there could be a restriction within the jurisdiction or bounds of the Crown Court.
That, as it would be, I think the development of the law, as explained in the Abbasi, would indicate that actually somebody who is freestanding, such as a person caught up in other litigation, could bring I think you'd have to, we wouldn't bring it before that court. You'd probably do what they did in INRI-S, where they brought it in the Family Division of the High Court. You'd probably bring your separate application, urgent application for an equitable injunction in relation to something which has happened in separate court, namely a Crown Court. That would certainly be one route. If you're looking at the Crown Court judge's powers, that's different, because the Crown Court judge, I assume, does not have the powers to reflect upon the tort of privacy, invasion of privacy in a context of criminal.
So what do you say about the first sentence in paragraph 18 of CUJA,
My Lord,
which seems to be of general application to the inherent powers of the court at common law to sit in private and to anonymise a material deployed in open court. You say that only applies to the Crown Court that has no inherent jurisdiction beyond withholding?
My Lord, it only applies to the Crown Court because it is not the case that there is no inherent jurisdiction of the court at common law to anonymise material and to impose reporting restriction orders. See the full analysis in A and BBC and para 34 of Wolverhampton, which actually expressly addresses this issue. And it all makes sense. So what this is concerned with is a different issue, which is A, in the Crown Court, and B, relating to what is in effect, but that's not the route which has been taken, but in effect the Venables type injunction scenario. So that there hasn't been a Venables injunction application, which, as I say, would probably have to take place in civil court.
I mean, it seems to be about the inherent power of the court at common law. Because that's what it says.
My Lord, what it says is referencing independent publishing and Attorney General, which itself is a criminal case, which again addresses the same issue, which is different from this issue, which is seeking to control that which it has been revealed in open court. That is direct press censorship. Prospectively seeking a withholding order coupled with a reporting restriction order is not direct press censorship. Because in the next hearing that will take place, the name will not be revealed. And the reporting restriction order is coupled to that. It's ancillary to that. It's part of giving effect to the anonymisation of the name of, in this case, the claimant. And that's why Lord Sumption says such strong language. This is direct press censorship in the Cuja case because it is completely different. It's back to para 55 in A and BBC. One thing is controlling the conduct of your proceedings. Another thing is seeking a contramundum injunction, which Abbasi has explained is basically what's been going on in Cuja. It wasn't, because an application wasn't made, but that's how it would be looked at in the future. And then only as a last resort do I say this was also obiter. We know it's obiter because Lord Sumption, at page 782 and following, para 31 and following, performed his own balancing exercise. So he didn't consider himself unable to do so. He did it through the prism of essentially convention rights. So the reference in AG in Trinidad, Attorney General Trinidad, to the name of the applicant who pleaded guilty and was proposing to give evidence to the prosecution not being withheld in open court is paras 6 to 7 at page 348. And that's why it was followed in Cuja, because it was exactly the same type of issue.
I mean, it's obviously intended to go beyond criminal proceedings because he says the statutory restrictions that he's talking about are first those that protect prejudicing the fairness of the proceedings or deterring parties and witnesses or victims of crime from participating, and secondly protecting children and young persons, which is mostly in family proceedings. So he's obviously, I mean, the context, paragraph 16, 17, 18, 19, is not about criminal proceedings. It's about proceedings generally and the inherent power of the court in relation to it. It's I mean, don't you have to say that this is A, overturned, B, inconsistent with subsequent cases?
My Lord, it's certainly been explained in subsequent cases. It's been explained in Abbasi. It's been explained as...
Well, it's not explained in Abbasi, is it?
It is, my Lord, because it's
They don't make any reference to Kuja, this passage in Kuja.
it's exactly explaining what it is that Kuja is actually doing.
Well, where? Show me.
I did, my Lord. It's paragraph 80. Go back to it. It's page 1251, my Lord. This paragraph, because I've leapt in and out of Abbasi, but this is part of Abbasi Part 2, the post-proceedings, post-best interest proceedings, what you do if you are, for instance, a clinician and you seek a contramendum injunction. And what you do, see the heading at paragraph 79, is you raise your cause of action. And what Lord Reid is doing is he's explaining that Kuja was essentially a claim for an invasion of privacy. And Kuja was analysed under convention rights, but what Lord Reid is doing is explaining in the paragraphs I also took you to, which started at 83 and ended up at 98, essentially saying actually you should look at those as domestic causes of action. Only if that doesn't work or some particular circumstances, it may be that you can look at it as a Section 6, Section 37 case. It's been a development, there's no question. It's a difficult area which has been developed. But what we can see quite clearly is that there is a world of difference between open proceedings that you then seek to say, please don't report that, that's press censorship, and prospectively controlling your proceedings.
I mean, the problem is that that's not an explanation of what is said in paragraph 18 of Kuja, because paragraph 18 is talking about the common law inherent jurisdiction of the court to protect its proceedings. And it's not explained by saying that Kuja can also be regarded as a case that was about an invasion of privacy. What actually Lord Sumption is saying at 18 is about the common law inherent jurisdiction.
In relation to...
The problem with this is that I think one has to sort of grapple the fact that Abbasi does not reconcile Kuja and other cases, for example, A and the BBC, which you place reliance on, and we have to.
Yes, Will. Absolutely.
You agree?
That you need to grapple with it, oh, absolutely.
We need to grapple with it.
Absolutely.
But I mean, sometimes cases, with the best will in the world, even in the highest courts in the land, are not reconcilable.
My Lord, you don't need to perform that reconciliation in this sense. You are concerned with a case on the side of the line that is the conduct of proceedings, for which the relevant guidance is obtained through A and BBC as confirmed in those short overture passages in Wolverhampton. You are not concerned with the other side of the line as identified in para 54-55 of A and BBC, which is contramendum injunctions relating to proceedings, brackets which have already been conducted in open court, which is the In Re S, Venables, Kuja, Abbasi Part 2 side of the line. So to that extent, my Lord, your Lordship need not respectfully be troubled.
So you'll show us now where the judge was wrong about this, will you?
Yes, of course, my Lord. My Lord, if your Lordship goes to page 289.
Yes.
Headed Reporting Restriction Orders at paragraph 51.
Of the judgment we're in now, are we?
Yes, please. So the core bundle,
Yeah.
tab 21,
Thanks.
page 289. starts at paragraph 51. The first thing to note is, in contrast to the court's wide powers to regulate its own process, there is no inherent common law power to grant reporting restriction orders. Relying on Cuja, paragraph 52 essentially says, I'll not follow the arbiter in Wolverhampton in favour of Cuja.
You say wrong.
Correct.
He says the suggestion there's a common law power to impose reporting restrictions was not the point in issue in Wolverhampton, and it conflicts with Cuja, in which the Supreme Court was directly considering the issue of reporting restrictions. So I'm going to follow Cuja. You say wrong.
Yes.
Wolverhampton was concerned with the power to grant in equity injunctions of all kinds.
Well, Wolverhampton at large was concerned with that. Lord Reid then distinguished
Yes.
reporting restriction orders, saying they're not what we're looking at when we look
Well,
at...
he didn't distinguish. He said that they are a subset.
No, they're not a subset, my lord. They are not equitable.
Not
They
equitable.
are
Not equitable.
common law.
Yeah, that's correct,
like
he did
like
say.
the embargo judgment, they are not part of the
So
equitable...
you say that your distinction between common law and equity was missed by the judge in these
Well,
papers.
not in the way that I wish to...
Well, you say the judge is wrong. This is the Court of Appeal. We've got
Yes,
to-
my lord, yes. But when I say missed it, I mean...
Well,
the,
I mean, look, it's a magisterial exposition of the law. So if it's wrong, we need to know precisely where. I mean, he's a
Absolutely,
very
my lord.
expert judge in this area.
yes, my lord, respectfully,
Yeah.
and it was prior to Abbasi and you turns on those matters which were put before the court at the time and so forth. But respectfully, my lord, absolutely that is wrong.
Yes. Okay. So 51 and 52 are wrong. Anything else
What is, I mean,
on this point?
on this point, no, respectfully, there's lots more in the judgment, but that's fairly self-evident just how pulls apart our analysis of that.
I know, but it is very helpful just to
Yes,
to identify the bits where
Yes, my lord.
you say no, that was misunderstanding what the submission
Yes,
is
my
that
lord.
I've just made.
Yes, my lord.
So it helps me if you
Yes, of
tie
course.
it down. I mean, I always look at it as getting your screwdriver into a judgment. And if you can get your screwdriver in and show that it's based on a false premise, then you
Yes,
have
my lord.
a better chance of winning on an appeal, particularly in a legal case like this, where the jurisdiction is very much in issue.
Absolutely, my lord. Well, the next issue I was going to address was the court's jurisdiction under Section 11 of the Contempt of Court Act.
Just
Yeah.
before you get there, so the judge was wrong at para 53 to start casting around for a statutory basis because he didn't need to do that at all.
Correct, my
The
lord.
question he needed to ask himself was whether it was necessary for the proper administration of justice.
Needed to apply the balancing exercise as set out in paragraph 41 in A and BBC.
Which is, well, that says it's all very fact sensitive, doesn't it?
Yes, my lord.
Okay.
Because
But it is,
because
the,
it is.
the balance is between competing rights or...
Well, the word rights is a bit loaded because
Yeah.
it sounds like convention rights.
Yeah.
But it's actually just balancing exercise between competing factors or interests, which can incorporate and include what can be described as rights. They don't have to qualify as
The
rights.
balancing test in your argument is being carried out in order to determine whether it's necessary in the interest of justice
Yeah.
to make your...
Absolutely.
Thank you, yeah.
And we don't actually have to say, oh, it's Article 8.
No, I've got that much.
Well,
It was the necessary interests of justice is the sort
Absolutely,
of apex, isn't it?
absolutely. That's it's a derogation. We have to establish it. These were the
I mean,
submissions I made
don't
earlier.
want to
Yeah.
go on about this, Mr. Ware, but
Yes,
I think
William.
it's where we sort of started this morning.
Yes, my lord.
When I tried, I thought valiantly, to see the distinction between an injunction which is necessary in the sense that it protects the interests of a vulnerable person in the future to attack from this or that bad actor on the one hand, and an injunction that is necessary to protect the court process. And what I think is said, or maybe said against you, is that this is not really an injunction to protect the fairness of the court process or the justice of the court process. This is an injunction which protects the claimant against things that may, but may well not, happen in the future if his or her identity gets out into the public domain. And I think, in a sense, that's what I put to you right at the beginning in a different way, but we've had the benefit of your, if I may say so, very coherent argument now. So we understand the point you're making, that this is all part of the common law inherent jurisdiction of the court to protect its own process, but I still don't see a very clear distinction between when you cross the line to protect against things that are outside the process that may happen, as against protecting the fairness of the process itself.
Well, Lord,
See the point?
may I, the last 5 minutes before the short chairman, seek to make my submissions in relation to that?
Yes, I'd love you to. Yeah.
The court is concerned here with a quantum-only clinical negligence personal injury claim. Purpose of the court's involvement is for the court to determine and award the appropriate amount of damages to the claimant, which damages should provide so-called 100% compensation or full compensation in order to meet both the past expenditure and the claimant's future reasonable needs for life, which are enormous in this particular case, with a child who requires double-up care 24/7 at a very extreme cost. So the purpose of the court's role is to ensure that the claimant is awarded sufficient damages to meet his ongoing, very considerable needs. Were it to be the case that the claimant was subject to exploitation, whether by friends, family, carers, members of the public, or whomsoever, that purpose would be frustrated. And so this is a case in which securing the proper administration of justice absolutely is engaged. The whole purpose of the anonymity order is the minimum possible derogation from the principle of open justice in order to provide critical mitigation against that extremely real risk to a vulnerable, highly vulnerable individual who is going to be in receipt of a tremendous sum of money. And that looking forward is exactly what Lord Reid explained is encompassed as part and parcel of the court securing the administration of justice. It's not just securing the administration of justice in the business of assessing the appropriate amount of damages to be awarded. It is so as to ensure that those damages reach their rightful home over the course of the claimant's life, however long or short that may be.
So which is the paragraph in Lord Reid that you rely upon for that? Because he didn't talk about rightful homes or damages reaching them.
My lord,
you said, I've written it down,
yes,
that is what Lord Reid explained as securing the administration of justice so as to ensure the damages reach their rightful home. Which is that passage?
That was prefaced by you saying that looking forward.
that was the looking forwards part, my lord. It's paragraph, thank you, my lord. That was paragraph 38 that I've taken to at page 614.
Of which case?
A and BBC,
Thank you.
page 614, paragraph 38. The administration of justice is a continuing process. The court can therefore take steps in current proceedings in order to ensure the interests of justice will not be defeated in the future. That's it, in a nutshell. It's an incredibly important aspect of our case. It may have taken me a while to work out in my own mind how to reach that and articulate it, but that's where I've landed.
Yeah. Yeah. Okay. Thank you.
Lord, is that a convenient moment?
Yes, 2 o'clock.